Executive orders expanding bans and putting dual citizens under new scrutiny are making headlines right now. And if you hold U.S. citizenship, a green card, or you're waiting on an immigration decision, you may be quietly wondering if something fundamental just changed about your security, your travel, or even your future in this country. Those words, expanded bans, dual citizens affected, sound heavy, almost ominous, and it's completely understandable if a small part of you has asked, could this impact me personally? Or is there something I'm missing that no one is clearly explaining? Because the truth is, most headlines are designed to trigger urgency, not clarity. And when policies are discussed in broad, dramatic language, they can easily make millions of people feel like they're suddenly under a cloud of uncertainty, even when the real impact is far narrower than it appears. That gap between perception and reality is exactly what we need to close today calmly and carefully, because buried inside all the noise is a simple question that matters more than anything else. Who is actually affected by this executive order and who is not? Hi, I'm Sophia, and I've been closely following immigration policy developments and executive actions for years, translating complex legal and political updates into clear, understandable explanations so you can stay informed without being overwhelmed or misled by alarming headlines. I'm not an immigration attorney, and this video is purely educational, not legal advice. But everything we discuss is grounded in publicly available information and the broader legal framework that governs how these policies actually operate in real life. My goal here isn't to sensationalize or speculate. It's to walk you through what this executive order really means, why the phrase dual citizens is suddenly appearing everywhere, and most importantly, to help you honestly assess whether your own status, travel, or immigration journey is realistically impacted. By the end of this conversation, you should feel less confused, less anxious, and far more confident about what has actually changed and what, for most people watching, has not. To understand why these headlines sound so dramatic, we first need to look at what an executive order like this actually does in practice. Because the phrase expanded bans creates the impression of a sweeping blanket policy that suddenly applies to huge groups of people when, in reality, most executive actions in the immigration and national security space operate in a much more targeted and procedural way. What's being discussed here involves expanded vetting measures, additional layers of security screening, and, in some cases, entry restrictions tied to specific countries that the government has identified as posing certain security concerns. That distinction is critical because enhanced vetting is not the same thing as a universal ban, and additional review is not the same thing as stripping someone of their legal status or rights. The government already has long-standing authorities to adjust how individuals from certain regions are screened when they apply for visas, travel to the United States, or seek admission at a port of entry. And executive orders often modify those procedures rather than rewrite the entire legal framework overnight. This means the policy conversation is really about how certain cases are evaluated, not about broadly punishing millions of people who simply happen to hold more than one nationality. This is also why the wording in headlines can feel much more sweeping than the actual policy text, because headlines compress complex legal nuances into a few attention-grabbing words. When you see phrases like bans expanded, what that often translates to in legal terms is narrower eligibility criteria for specific visa categories, additional documentation requirements, or deeper background checks for travelers connected to a small list of countries that have already been under some level of scrutiny for years. It's not a sudden rewrite of citizenship law, and it's not a declaration that dual nationality itself is suspicious or disallowed. In fact, the legal foundation that permits Americans to hold dual citizenship has not changed at all. U.S. law has long recognized that people can have legitimate ties to more than one nation, whether through birth, marriage, family connections, or practical realities like property ownership or inheritance rights abroad. Millions of Americans quietly live with dual citizenship and have done so for decades without any disruption to their legal status, daily life, or sense of belonging. So, when the term dual citizens appears in policy discussions, it doesn't mean that all dual citizens are suddenly under investigation or at risk. It usually means that in very specific scenarios, particularly involving travel or entry screening, The existence of a second citizenship may be one of several factors considered during a security review. And this is the point where fear often starts to build unnecessarily because the mind naturally jumps from additional scrutiny in narrow cases to broad suspicion against anyone with two passports, which is not how the system actually operates. Holding dual citizenship by itself is completely legal and widely accepted in the United States. And the government does not automatically penalize or downgrade someone's rights simply because they maintain citizenship in another country. There is no provision in these executive actions that says your U.S. citizenship becomes weaker, conditional, or revocable just because you were born somewhere else or chose to retain a second nationality. Your passport, your rights, and your legal status remain anchored in the same constitutional and statutory protections that existed before these headlines began circulating. What changes in the limited scenarios actually covered by such orders is not your identity as an American, but the level of administrative scrutiny that might apply when certain travel or security-related factors are present. So when people ask, does this mean dual citizens are now targeted? The more accurate answer is that dual citizenship becomes relevant only when it intersects with very specific national security designations tied to particular countries, not as a standalone issue. If someone holds U.S. citizenship along with citizenship in a country that is not named or restricted in any way, then these expanded vetting measures typically never come into play for them at all. Their travel, employment, and everyday life continue exactly as before. But if a person does hold citizenship in a country that appears on a restricted or heightened review list, then the system may require additional questions, documentation, or processing time when that person travels internationally or applies for certain immigration-related benefits. Even then, that extra scrutiny is procedural, not punitive, and it does not equate to a loss of citizenship, a presumption of wrongdoing, or an automatic denial of entry. Understanding this distinction is essential because it shifts the conversation from a vague sense of collective risk to a much more precise evaluation of who is actually affected and in what limited ways. Most people watching right now are not dealing with any of the specific factors that trigger these additional layers of review. And yet the emotional weight of the headlines can make it feel as if a broad shadow has been cast over all immigrants, naturalized citizens, and dual nationals. That emotional reaction is human and completely valid, especially for individuals who have spent years building their lives in the United States and who naturally want reassurance that their status is secure. But the legal reality is far more stable than the language of the headlines suggests. Dual citizenship has never been illegal in the United States. It remains legally recognized today. And nothing in these executive actions suddenly transforms millions of law-abiding dual citizens into people whose loyalty, status, or future is automatically in question. So the real question becomes much more precise and much less frightening once we ask it the right way. Who is actually affected by these expanded restrictions, and under what circumstances do they even come into play? Because when you narrow the lens and look closely, you begin to see that the scope is not nearly as broad as many people initially assume. In most cases, these executive actions focus on individuals who hold citizenship in a very small number of specifically named countries that the U.S. government has designated for heightened security review due to ongoing conflicts, intelligence sharing limitations, or other geopolitical concerns. That means the policy is not about dual citizenship in general. It is about dual citizenship connected to those particular countries, and usually only in the context of international travel, visa processing, or entry screening. If you are a U.S. citizen who also holds citizenship in countries like Canada, the United Kingdom, Germany, France, Japan, Australia, or most other nations around the world, these expanded vetting measures almost certainly do not apply to you at all. Your legal status, your ability to live and work in the United States, and your basic rights as a citizen remain exactly as they were before these headlines began circulating. Even for individuals whose second citizenship is tied to a country that appears on a restricted list, the implications are often far more limited than the word ban would suggest. In many cases, the change may simply involve additional questions during international travel, requests for extra documentation, or longer processing times for certain applications. That is very different from being denied entry to your own country or being placed at risk of losing your citizenship. If you are a U.S. citizen returning home, you have the legal right to enter the United States, and that right does not disappear because you hold another passport. The system may ask more detailed questions in certain scenarios, but those questions are part of administrative review, not a judgment that you are less American or less entitled to the protections of citizenship. For green card holders, the situation is similar in principle. Permanent residency is a legally protected status that cannot be revoked arbitrarily, and holding dual citizenship alone is not grounds for deportation or removal proceedings. If additional scrutiny occurs, it is usually tied to travel patterns, security flags related to specific countries, or individual case details, not simply the existence of a second nationality. This is where a lot of confusion and anxiety tend to arise because people often assume that if a policy mentions dual citizens at all, it must apply broadly to every dual citizen everywhere. In reality, immigration and national security policies are almost always written with precise categories and triggers, not sweeping assumptions. They are designed to identify specific risk factors, not to cast suspicion on millions of ordinary people who happen to have family, cultural, or legal ties to more than one country. For the overwhelming majority of viewers, especially those whose second citizenship is with nations that maintain strong diplomatic and information sharing relationships with the United States, life continues exactly as it did before. Your passport does not suddenly become weaker. Your citizenship does not become conditional. And your place in this country is not up for quiet reconsideration just because a new executive order adjusted screening protocols in narrowly defined situations. But despite that narrower reality, several powerful myths have begun circulating online. And these myths are often what truly fuel fear and uncertainty. One of the most common claims is that the government is preparing to revoke citizenship from dual citizens on a wide scale, as if holding more than one nationality has suddenly become suspicious or disqualifying. That claim does not align with how U.S. law actually works. Revoking citizenship, a process known legally as denaturalization, is extremely rare and requires a federal court case. Substantial evidence of serious fraud or criminal misconduct during the naturalization process, and years of legal proceedings where the individual has the right to defend themselves. It cannot happen automatically, and it cannot happen simply because someone has dual citizenship. Another widespread myth is that dual citizens will be routinely detained at airports or prevented from re-entering the United States. In reality, U.S. citizens, regardless of whether they hold another passport, retain the fundamental right to return to their own country. Additional questioning may occur in very specific cases, but questioning is not the same as detention, and inconvenience is not the same as legal jeopardy. A third myth suggests that green card holders with dual citizenship are now being targeted for deportation solely because of their nationality. Again, this does not reflect the legal framework governing permanent residency. Deportation requires formal legal proceedings, evidence of specific grounds for removal, and opportunities for the individual to contest the case before an immigration judge. Simply having citizenship in another country does not meet that threshold. The gap between these myths and the legal reality is significant, and understanding that gap is one of the most important steps you can take to regain a sense of calm and control. When policies are complex and headlines are simplified for maximum attention, it becomes easy for worst-case scenarios to feel inevitable, even when they are actually rare and highly conditional. By separating what the policy text actually targets from what online speculation suggests, you begin to see that the real impact is focused on a relatively small set of situations, not on the everyday lives of millions of dual citizens, naturalized Americans, and green card holders who continue to live, work, travel, and build their futures under the same legal protections that existed long before this executive order was announced. Sometimes the easiest way to understand how narrow these situations really are is to step away from abstract policy language and look at realistic, everyday examples that mirror the lives of people watching right now. Imagine someone like Maria, who was born in the Philippines, immigrated to the United States decades ago, and eventually became a naturalized U.S. citizen. She still technically holds Filipino citizenship because her birth country allows it, and she occasionally travels to visit family. For Maria, nothing in these expanded executive actions meaningfully changes her life. She continues to live, work, vote, and travel exactly as she always has. Because her second citizenship is tied to a country that is not subject to any special restrictions or heightened security designations. Her U.S. citizenship is fully secure, her rights are intact, and her daily routine remains untouched by the policy shifts dominating the headlines. Now consider a different example. Someone like Ahmed, who is also a U.S. citizen, but happens to hold citizenship in a country that appears on a restricted or heightened review list. Ahmed's situation is not one of losing status or facing removal. Instead, the practical difference might be that when he travels internationally, he could experience additional questions at the airport or need to carry extra documentation to clarify his travel history and ties. That experience may be inconvenient and occasionally stressful, but it is still fundamentally different from being denied entry or having his citizenship questioned. He remains a U.S. citizen with the same constitutional protections, the same right to return home, and the same legal standing as any other American. These two examples highlight a critical point that often gets lost when policies are discussed in broad terms. Rare specific scenarios should not be mistaken for universal realities. The existence of a small category of individuals who may face additional procedural review does not mean that millions of others share the same exposure. Yet, when people see the words dual citizens affected, the mind naturally generalizes and assumes that the label applies equally to everyone who holds two passports. That generalization is what fuels so much unnecessary fear, especially among naturalized citizens who sometimes quietly worry that their status might be more fragile than that of someone born in the United States. That concern is deeply understandable because the naturalization process requires years of waiting, paperwork, interviews, and emotional investment. And once you finally reach that milestone, the idea that a policy shift could somehow undo it feels profoundly unsettling. But this is precisely where it becomes important to separate emotional perception from legal reality because the law draws far stronger lines of protection than many people realize. Once a person becomes a U.S. citizen through naturalization, they gain almost all the same rights and protections as someone born on American soil. The Constitution does not create a second tier of citizenship based on place of birth. And the legal threshold for taking citizenship away is intentionally set extremely high. Denaturalization is not an administrative shortcut that can be triggered by a new executive order or a change in political climate. It is a complex legal process that requires the government to prove in federal court that citizenship was originally obtained through willful and material fraud or serious concealment of facts, such as a hidden criminal history or false identity. Even then, the process unfolds over years and includes opportunities for the individual to present evidence, challenge the claims, and appeal decisions. Simple mistakes, forgotten details on applications, or the mere existence of dual citizenship do not meet this threshold. The legal system distinguishes very clearly between intentional deception and the ordinary imperfections that appear in long, complicated immigration histories. And that distinction provides a powerful safeguard for millions of naturalized Americans who sometimes worry that their citizenship is more conditional than it actually is. This is also why it is misleading to assume that executive actions aimed at travel screening or entry procedures could somehow override the constitutional and statutory protections attached to citizenship itself. Executive orders can influence how agencies conduct background checks, what documents they request, and how certain risk factors are evaluated during immigration or border processing. But they do not have the power to silently rewrite the legal definition of citizenship or strip people of their rights without due process. The separation of powers built into the U.S. system means that courts, statutes, and long-established legal precedents all act as guardrails against sudden sweeping changes to fundamental status. In practical terms, that means the fears many naturalized citizens carry in moments like this. Fears that their citizenship might be easier to question or easier to revoke are not supported by how the legal framework actually operates. Your citizenship is not provisional. It is not dependent on daily political headlines, and it does not quietly weaken because a policy adds extra screening layers in a narrow set of travel-related scenarios. The protections that came with your oath of citizenship remain in place, anchored in law and reinforced by decades of legal precedent that make abrupt, arbitrary revocation extraordinarily difficult and exceedingly rare. Another source of anxiety that often gets mixed into these conversations is the slow pace of immigration processing itself. Because when people are already waiting months or even years for updates on their applications, any new policy headline can feel like a hidden explanation for those delays. It becomes easy to think maybe my case is stuck because of these new restrictions, or maybe the government is taking a closer look at people like me now. But in most situations, the reality is far less personal and far more systemic. USCIS and many related immigration agencies are currently dealing with significant backlogs across a wide range of application types, including green cards, work permits, naturalization cases, and family-based petitions. Processing times have lengthened for millions of applicants, regardless of their country of origin, dual citizenship status, or travel history. That means a delay in your case is far more likely to be a reflection of overall workload and limited resources than a targeted review triggered by recent executive actions. When agencies are overwhelmed, everything moves more slowly, and that slowness affects nearly everyone navigating the system, not just those connected to any specific policy discussion. It is also important to remember that policy announcements and real-world implementation rarely happen at the same speed. Even when an executive order introduces new screening procedures or revises how certain risk factors are evaluated, agencies must still update internal guidance, train officers, adjust forms and databases, and sometimes even defend the policy in court if legal challenges arise. All of that takes time, and during that period, existing cases usually continue to move forward under established procedures rather than being abruptly reclassified overnight. This gradual implementation process can feel frustrating when you are waiting for progress, but it also serves as a form of protection. Because the system is procedural and layered, it prevents sudden sweeping changes from instantly disrupting the legal status of large groups of people. Instead, adjustments are absorbed slowly, reviewed carefully, and often refined through administrative and judicial oversight before they fully take shape in everyday casework. In a way, the very slowness that so many applicants find exhausting is also what helps maintain stability and predictability in the immigration system. Major policy shifts do not simply flip a switch that alters everyone's situation at once. They pass through a series of legal and administrative checkpoints that give individuals time to understand the changes, seek advice if needed, and respond appropriately. Courts may review whether the policy stays within statutory authority. Advocacy organizations may challenge aspects they consider overbroad, and agencies themselves may issue clarifying memos that narrow how the rules are applied in practice. This layered process means that even when headlines sound urgent, the underlying legal machinery moves deliberately, not chaotically. For most people, that deliberate pace translates into continuity rather than sudden disruption, even during periods of intense political debate around immigration. This brings us to a broader perspective that can be reassuring once you see the full picture. The U.S. immigration and citizenship framework is built on due process, defined procedures, and multiple levels of review, not on instantaneous executive discretion that bypasses all safeguards. Executive orders can guide agency priorities and screening criteria, but they operate within a larger legal ecosystem that includes statutes passed by Congress, constitutional protections, and judicial oversight. When a new restriction is announced, it does not erase those existing foundations. Instead, it must fit within them and withstand potential legal scrutiny. That reality explains why so many dramatic policy announcements over the years have ended up being narrowed, delayed, or partially modified after closer examination by courts and agencies. The system is far from perfect and often painfully slow, but that very complexity creates buffers against abrupt, arbitrary outcomes that would otherwise generate far more instability. Understanding this structural context can transform the way you interpret alarming headlines. Rather than viewing each announcement as an immediate personal threat, you can begin to see it as one piece of a larger, slower-moving process that unfolds through rules, reviews, and legal boundaries. This doesn't mean every policy is harmless or that concerns should be dismissed outright, but it does mean that change in the immigration space is almost never as sudden or as sweeping as initial coverage suggests. Your case, your status, and your rights remain embedded in a system that requires evidence, procedure, and oversight before meaningful legal consequences can occur. That framework is what keeps individual situations from being reshaped overnight, even when political messaging makes it sound as though everything has shifted in a single announcement. So, given all of this, the most helpful response is not panic, but preparation combined with perspective. Because when you understand what is actually changing and what is not, you can take simple, practical steps that give you a sense of control without overreacting to headlines that may not apply to your situation at all. The first step is to stay informed, but to do so intentionally rather than obsessively. That means relying on official government updates, reputable news sources, or qualified legal commentary instead of unverified social media posts that often amplify worst-case interpretations without context. When you read about new restrictions or expanded screening, take a moment to ask whether the policy actually names your country of citizenship or your immigration category. If it does not, then the likelihood that it directly affects you is usually very low. That single habit of pausing to verify the scope of a policy can prevent a great deal of unnecessary stress and help you separate general news from personal risk. Another practical step is simply to keep your important immigration and identity documents organized and accessible. Not because you are expecting trouble, but because being prepared always makes any interaction with the system smoother and less intimidating. Having copies of your passport, naturalization certificate, green card if applicable, travel history, and address records in one secure place ensures that if you ever do need to answer questions, consult an attorney, or complete an application, you can do so confidently and efficiently. This kind of organization is not a reaction to fear. It is a standard best practice for anyone navigating immigration processes, regardless of changing policies. It reinforces the idea that preparedness is about empowerment, not alarm. At the same time, it is equally important to avoid drastic decisions driven purely by anxiety, such as rushing to renounce a second citizenship, canceling necessary travel plans, or spending large sums on legal consultations when there is no clear indication that your individual case is at risk. Acting out of fear can sometimes create complications that would never have existed if you had simply paused, gathered accurate information, and assessed your situation calmly. Of course, if your specific circumstances are genuinely tied to one of the restricted countries, or you have a complex immigration history that raises unique questions, then seeking advice from a qualified immigration attorney is a wise and measured step, not an emergency reaction. A brief consultation can clarify what documentation you should carry, what to expect during travel, and whether any proactive measures are advisable. For most people, however, that level of intervention is unnecessary. And recognizing when you do not need to escalate your response is just as important as knowing when professional guidance is appropriate. The goal is not to ignore policy changes, but to respond proportionally, matching your level of concern to your actual level of exposure rather than to the intensity of the headlines surrounding the issue. Beyond these practical steps, there is also an emotional dimension that deserves acknowledgement because immigration policies are never just abstract legal instruments. They intersect directly with people's sense of safety, belonging, and long-term stability. For many immigrants, naturalized citizens, and dual nationals, the journey to this point has involved years of sacrifice, uncertainty, and hope. So, any suggestion that their status could be questioned naturally triggers deep-seated fears that go far beyond the technical details of a policy memo.